Okay.
Thank you so much. Hey, welcome everyone. It's 2:08 on July 18th, 2024. We are having our Indigent Defense Commission meeting to get started. And since we do have a special guest, let's go quickly around and share your name, please, and then what discipline in the law you represent. So Laureen Kamalu, and I am here on behalf of the Utah Association of Counties with the larger populated counties, first and second class. And let's go to Michael Zimmerman.
Yeah, I'm a former member of the Utah Supreme Court long ago, and I'm the Judicial Council representative on the IDC.
Thank you. Tom.
Tom Ross, Executive Director of the Commission on Criminal and Juvenile Justice, and I'm on the IDC because of that role.
Yes. Margaret.
Margaret Lindsay, Utah County Public Defenders Association, and I am assigned to be a child welfare representative.
Yes. Pam.
Hi, I'm Pam Vickery. I am a juvenile delinquency attorney.
Thank you. Mary.
Hi, I'm Mary Corporon. I am a criminal defense attorney in private practice, and I am appointed, I believe, by the Utah Association of Criminal Defense Attorneys, or lawyers, actually, UACDL, for to fill the seat that is designated for an appointee by that agency.
Yes. Michael Drexel. Oh, we can't hear you. Oh, there you are.
You hear me better now?
It's really weird. Like you sound like a robot.
So, I'm Michael Drexel, Administrative Officer of the Courts and the Assistant State Court Administrator.
Thank you. Yeah, he's actually a really cool guy. That sounded really weird. Knows his stuff. Okay, Rich.
I'm Rich Morrow. I'm the director of the Salt Lake Legal Defender Association, and I am the Public Defender Agency representative on the IDC.
Yeah. And Commissioner Hopes.
Casey Hopes, appointed by the Utah Association of Counties for third, fourth, and fifth class counties.
Yeah, lesser populated counties, rural counties. Thank you, Casey. Okay, and then we have staff, Katrina, and we have Josh, and Adam, and Matt, and I think that's the group. Did I miss anyone? I think we got it. Awesome. Okay, first up is our approval of minutes.
We do have a guest.
Oh, yeah. Amy, I
Laura.
think you're going to get a full intro soon, but why don't you at least share your name and where you're from?
Sure. Hi, everybody. I'm Amy Baror. I am with the Galt Center, and you'll be hearing from me in just a little bit about our assessment of Utah's youth defense system.
We're so excited to have you. Thank you. All right. Approval of minutes. I think you probably sent these, Katrina, in a former email.
I'll move the approval of the minutes.
Second that.
Okay, Michael Zimmerman, a motion, and I heard Mary a second, and all in favor.
Aye.
I
Any opposed? All right, they're good. Minutes are just so great. Thank you, Katrina. Okay, now we're ready for Matt to go ahead and introduce Amy. Oh, is that right, Katrina, or did we miss something?
I think we should probably go to the grant discussion first.
Oh, that's right. Sorry, Matt, go ahead and start with that.
Okay, we do have a grant modification that we wanted to present to the commission. Let me get this going here.
Mhm.
All right, can everyone see that all right?
Yes.
Okay, so this is regarding Wasatch County. So Wasatch County is a newer grant recipient. They came on board a year ago, just with the last grant cycle. And just to remind everybody of how they ended up being a grant recipient, We were in talks with them in the fall of 2022 about applying for a grant. At that time, they were operating just with a sole contract, and the Facemeyer Law Group was providing those services. And we talked with Utah County Public Defender's Office about providing the management. They were already providing management and administrative support for the outer counties, as we called them. So Juab and Millard, and at the time, San Pete County. And so they were willing to take over management for Wasatch as well. And as part of that management, they got a head start. The grant would have gone into effect in June of 2023. And so they started actually engaging with Wasatch in January of that year. And what they did is, and part of the impetus for this was that the Facemeyer law firm was not planning on renewing their contract in district court. And so Utah County Public Defender was able to get 3 contract attorneys to handle the district court, and they split the calendar amongst those 3 attorneys and used the existing funds that were available there in Wasatch County to pay those attorneys. As they learned more about the work that was being done then by those attorneys, they were tracking hours. With the split in the contract, those 3 district court attorneys were being paid about $54,000 annually for the contract, and they were working about 30 hours a week each. So not a lot of money in that contract for the amount of work they were doing. In gearing up for the grant application, we did our review of the caseloads and the data and made recommendations, and we had our collaborative meeting with Utah County Public Defender Management and with Wasatch County officials. And what we recommended was that we add an additional contract to district court to lighten up that load. That would make those caseload numbers go down, and it would make that split of the funding more reasonable. And if you remember at the time, and to this day really, we were not considering compensation increases for contracts. And so this was a way that we could provide more support without actually increasing the value of the contracts. As part of that, we did, and the commission did, grant some non-lapsing funds to this project so that they could try and get somebody on board sooner rather than later, so that those attorneys were not so overwhelmed. And so that was made available in April, and they tried filling that, and we're having a hard time finding somebody to take that additional contract. Now, at some point in April, before the grant was determined, the Utah County Public Defender's Office had a conversation with one of our staff members about the possibility of using the grant funds rather than funding a new position, actually dividing that up amongst the 3 contractors who were doing the work. However, that was never formalized in what we recommended to the commission, and that was not what was actually approved by the commission. The commission did approve in the June of 2023 funding for another attorney position to help with that caseload. So why we're talking is because Utah County Public Defender's Office had a hard time filling that extra position, and they ended up redistributing the grant funds amongst those three contract attorneys. We didn't really become aware of this until this last grant cycle, about a year later, when we were considering the awards. Again, they had asked to split that money. It was just over $50,000 amongst the three grant holders, the three contract holders. And we denied that request. And then it became apparent that there was some kind of misunderstanding where we were not aware that those contracts were already in place at that time with that amount. So at this point, Utah County, well, Wasatch County through Utah County Public Defenders is concerned that those attorneys, now that they've been doing that work for that rate, may not renew their contracts if those were to be reduced accordingly. So the request is to modify the grant to allow for those contracts to continue as they are. And I will say that we did a review of the other contracts and grants that Utah County Public Defenders has received through the IDC, and it does appear that this is a one-off. We haven't found anything similar as far as grant money being used for other purposes. So at this point, I think a couple of things. We are recommending that the grants be modified accordingly. I would note just that even with the increase, those are within a reasonable compensation amount for that amount of work that those attorneys are doing. The issue, I think, is the actual money itself. Everybody knows that we are in a very tight budget situation this year. And what I am recommending to the commission that we do is that we reduce the funding for the managing defender compensation in that area and transfer that over to those contracts. The reason for that is that the managing defender for the outer counties, he's currently supervising 5 district court full-time employees. There are several contracts, but they add up to about 5 district court full-time employees. He is not carrying a caseload, and so his contract is already a bit out of alignment with other managing defender compensation throughout the state. For example, the managing defender in Washington County is compensated at $50,000 to manage almost twice as many full-time employees. So this would bring things to where they actually should be with the managing defender's compensation there. And so it's no additional funding coming out of our grant program. It's moving it from that managing defender position to the Wasatch contracts. I did, when we were looking at grants statewide with our funding reduction, we did become aware that this was a situation there with Washington, with the outer county managing defender grant. And I did have a conversation with Tom Means about this back in May, I believe, about that managing defender position being overfunded essentially, and let him know that that was an issue that we were going to have to address. And so they are aware at least that that is an issue. We have not discussed this actual plan of reducing it because we wanted to talk to the commission about it first. So that is the situation in Washington County. Those are or Wasatch County, and those are our recommendations, and I'm happy to take any questions that anyone might have.
Okay, thanks, Matt.
I'd make a motion, we approve the recommendation.
Oh,
I mean,
thanks.
given the disparity already in terms of Washington County, and it seems like an opportunity we want to support. We want to support Wasatch.
Okay,
I'll second that motion.
Okay, motion and a second. Are there any additional discussion or questions by anybody?
Yeah, I actually, Madam Chair, I do have a question, or a couple of questions. Number one, so Matt, as I understand it, what we're doing, are we reducing the salary of the managing defender for Joab Millard Wasatch?
Would be a reduction, yes. Yeah.
Has there been any discussion with the managing defender about that yet?
I did talk to the director of the office, Tom Means, about that.
Okay. So, because I guess my question is this on the radar screen of the managing defender, and will we be sort of looking at having to deal with the situation where that person may be completely blindsided and say, hey, I'm not going to do this anymore?
Mm-hmm. Yeah, that's certainly a possibility. I have to say there was some frustration, I think, just with this whole situation, how it developed and presented itself. I'm not saying that that's necessarily the fault of the managing defender, and I don't mean to imply that this is some kind of consequence for him directly because of this happening, but with the funding being as tight as it is right now, and having to really make some big cuts into our non-lapsing funds and our reserves, I think it's entirely appropriate to move in this direction.
The second question I have is from the Wasatch defenders. Do they track their caseloads? Do you have caseload information about what they're handling, types of cases and things like that?
We do. Yeah.
Okay.
Yeah.
Does it seem to be consistent that they merit, based on that, they merit sort of a higher rate of pay, in your opinion?
Yeah, they're reporting that they're working about 30 hours a week each, and so I think that higher compensation, it's reasonable. It's certainly reasonable. It's within, and the 50,000 for doing 30 hours a week is, I think it's objectively low.
Yeah, no, I don't dispute that. I'm just curious. As long as you have all those ducks, I'm good with it. So thanks.
Sure.
I think someone else had a question, or maybe.
This, Tom, I just went off mute, but no, I'm supportive moving forward. I had more concerns about it before Matt, gave all the explanation. I don't like the way it happened, which sounds like Matt and probably most all of us feel it's always unfortunate when we say no to something someone wants and then they do it anyway. But I'm getting the impression, Matt, from the conversation that it may not have been as much as a flat out ignoring and just doing, and maybe there was some confusion and people felt they were doing the right thing in the right way. If it was in the explanation that this money brings it more in line with what it should be, and we're actually shifting it from, it's not even new money, based on all those things, I'm supportive of it.
Thank you. And
I mean, I think that given the tight budget that we have, and I think that's a way to explain, if we can get some more money this next session, that we can restore whatever it is, if that's appropriate. I mean, is that the kind of conversation you can have, Matt?
I mean, I would always welcome more resources to do more things throughout the state. I think that in order for that compensation to be restored, though, I mean, there still is that objective issue where the compensation for that role, the managing defender role, was out of alignment with other managing defenders. So I think that if that were to be a discussion of restoring that, there would need to be some additional responsibilities to justify it.
Yeah, the equitable pay is a really big deal, right?
Yeah.
Margaret.
I just make a couple comments. Obviously, I will be abstaining on this vote, but and this is not my area in the office. And so I don't have a perfect handle on what happened, but I do know the parties involved, and I can't imagine that there was any intent or to blatantly disregard or even disregard. I think it was probably an unfortunate circumstance. I do know that Wasatch hasn't been the easiest transition. And there is adding another, big piece to the pie. I do know this, that I believe the managing defender, while not having a caseload, frequently sits and works as like second chair and things when there's some big trials. So I do know there has been involvement, especially in Juab and Millard counties on that end. But other than that, those are just comments. I don't have a position on the motion.
Thank you, Margaret. Okay, anyone else? Got great questions and discussion and comments. And we welcome Senator Weiler and Representative Clancy. Thank you so much from our state legislature. So, okay, we have a motion and a second, and maybe we'll repeat that motion for the two who are able to just join in. But this is how do you want us to describe it, Matt? Just don't go all the way through everything, but just what do you want to title it? A motion for two.
It's a grant modification, and it would be a reallocation of some funds within the Wasatch County system.
Yeah, that's a great way to say it. Thank you. Okay, so I have a motion and a second. All in favor, let's say aye.
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 Aye. Aye.
Got the ayes. I think I've seen everybody, but are there any opposed? Please say nay. Okay, it is a unanimous vote in the affirmative. Thank you for going through that and helping us to understand.
Take note that Commissioner Lindsay is abstaining.
Oh, okay, that's right. Thank you for capturing that for the minutes. That was good. Yes, appropriate. Okay, great. So now we moved that to the beginning so that we could make sure we had our quorum, and we have a great attendance today. Thanks, everybody. So let's now go to our Galt Center report, and Matt will introduce Amy from the Galt Center report. Going to share, and I guess are you located yourself in Washington, D.C., Amy?
I'm in Ohio, actually.
Okay, but the Galt Center, I guess, is in D.C.
We're actually fully remote, so we're incorporated in DC, but our 12 staff are in 10 different states, including one in Utah.
Oh, wonderful. Great. Well, Matt's going to introduce you. Go ahead, Matt.
We are very happy to have Amy Borer here. She is the Senior Youth Policy Strategist with the Galt Center. The Galt Center is an organization that focuses on policy related to youth defense throughout the nation. They provide training and technical assistance, and they conduct assessments, statewide assessments, to take a look at how services are being delivered within that state and make recommendations. And so at our invitation, the Galt Center performed one of these assessments here in Utah, and I'll let Amy describe that assessment, how it took place, and what the findings and recommendations are. But we're really happy to have her here to join us today.
Thank you so much, Matt. I am going to share my screen. There we go. And is that showing up for everybody? Okay. So like Matt said, my name's Amy Borer. I'm the Senior Youth Policy Strategist at the Galt Center. Thank you so much for having us. So we, like Matt said, we're a national organization. We used to be based in DC. All of our staff was in DC. When the pandemic hit, we went remote, stopped paying DC office rent. And the great thing about it is that all of our staff used to be located in the DC area. And now that we actually have nationwide staff, it really does kind of introduce a new and unique, I think, national perspective to the work that we do. And so, like Matt said, we did an assessment here in Utah. We released it just a few months ago, and Matt invited me to come and brief you all on what the process was, what our findings and recommendations are. I do have a PowerPoint. I'm happy to answer questions throughout and or after. So if there's something that you want to pop in and interrupt me and ask for more detail, please absolutely feel free to do that. So what I plan to go through today is starting off with a little bit of background and explaining to you what our process is so that you understand what we did in Utah and what we do whenever we're invited into states. I'll give kind of a high level overview of our findings and recommendations. And this is kind of a 30,000 foot view. And it's the same kind of overview that we give whenever we're briefing anybody in the state. But because this is the Indigent Defense Commission, I'm also then going to go into a little bit more detail and really talk about what through our assessment we found that we think youth defenders across the state really need, and how the system can help support and strengthen youth defense. So state assessments of youth defense delivery systems are a foundation of the Galt Center's work. We were originally known as the National Juvenile Defender Center, NJDC. Perhaps you're familiar with that name. We changed our name in 2022. We're now the Galt Center, named after In re Galt, which is a U.S. Supreme Court decision recognizing children's constitutional right to counsel. So we've been doing state assessments for as long as we've existed as an organization. Our first was in the state of Texas in 2000. Our goal is to eventually get to every state. Utah is our most recent and our 29th state assessment. So we have done more than half of the states now. So what we do whenever we do an assessment of a state's statewide youth defense delivery system, one, we only go into a state when we're invited. This isn't some sort of secret investigation. It's not a gotcha. We're not trying to sneak in and find things that people are doing wrong. We only go into a state when they want us there. We want folks who know we're there, who know when we're listening, who are interested in genuinely learning how their system is performing, and are open to the idea of addressing concerns that we might find. So every state that we've done has invited us in. Here in Utah, like Matt said, it was the Indigent Defense Commission that officially invited us, working very closely with the Administrative Office of the Courts. So once we're invited into a state, our staff really starts to do a deep dive into the state and do what we call system mapping. So we learn as much as we can about the structure of the court system, the delinquency laws, any data that's available. Some states have tons of data, some have none. Lots of them fall somewhere in between. We look at population and demographics and juvenile court filings and crime rates. We look for any kind of anomalies across the state. With just a few exceptions, we generally can't be on the ground everywhere in a state when we're doing an assessment. And so we really try to map the state and figure out which counties we can visit in person to get a good representative sampling of what's actually happening on the ground. So the intention is that this is a statewide assessment, and in a place like Utah, right, it really is kind of like 30-ish different systems running, but under the umbrella of the state. And we really try to get a look at what the state overall looks like. So we do the system mapping. We pick a representative sampling of counties. That's what we call site selection. We do outreach to those counties, and we just talk to everybody that we can over the phone first to really get a sense from them on the ground. When is court held? What does it look like? When should we be there? And then we start to do our site visits. So Utah was unique. This was the first kind of post-COVID, or in some ways during COVID, assessment that we did. It was a longer process because of that. Usually from the time that we're invited until the time that we release the report is somewhere between 18 and 24 months. This was, I think, 28-ish months. And that was because this was still, so we were first invited in, I think it was February of 23, I think it was. And we did have a surge that late summer in COVID. And so we were originally scheduled to be on the ground. I think it was late summer 23, I think. 22, my years are getting mixed up. Anyway, we were originally scheduled to be on the ground. We ended up pulling the plug on it and postponing until the following year. But what we did during that time was, for the first time ever, we did court observations of virtual court hearings. So when COVID first started, I think that we and lots of folks thought the switch to virtual court is just a temporary thing, right? The pandemic's going to be over in no time. None of us knew what was coming. But the longer it went on and the more courts got adjusted to it, the more we and others recognized that we're not really going to go back to what things were before when it comes to virtual hearings. And so we worked with some researchers and we modified our court observation protocols, and we did some virtual court observations in that time frame where we weren't able to be on the ground. So we did finally get on the ground March through May of 2023. We visited 8 counties. We conducted more than 60 interviews of juvenile court professionals. We observed more than 120 court proceedings, and we toured 5 youth detention and commitment facilities. So after we're on the ground, then it's a months-long process of compiling all the notes and data that we get. So this is largely a qualitative analysis. Quantitative is numbers. There's some of that, but for the most part, this is qualitative. This is interviews, notes from interviews, court observations. And so it takes a long time. And we do use some what's called qualitative research analysis software. This year for Utah, we used a program called Deduce. And it's a way that we can kind of sort through, we end up with piles and piles of notes and court observations, and it lets us kind of map all of that and identify themes that arise. So once we're done with report drafting, we start briefing some of our state partners. So we briefed Matt and Adam, we briefed some judges, we briefed Brett Peterson, some of the folks, the AOC, some of the folks who kind of invited us in to give them a heads up of what we found before we actually release the report. Then we release the report, and here in Utah, we release it on May 15th of this year. May 15th is the anniversary of the In re Galt decision. And then after we release the report, we are ready to jump in and help support any implementation efforts. So we really defer entirely to those of you on the ground. You're the experts in Utah and in Utah's youth defense system. And whatever you want to take away from the assessment report and whatever you prioritize is what you decide you want to start working toward, we defer to you. And we are here to support you how we can. So, as this commission really kind of dives into the report and makes decisions about what you want to do, where we can be helpful, please let us know. And states really approach them all very differently. Some states dive into training, some states, go for additional funding, some states try to move towards statewide systems. So I, prior to joining the Galt Center, I worked at the State Public Defender's Office here in Ohio for about 13 years. And the year before I started, the Ohio and then NJDC's Ohio assessment report came out. I started the next year, and I used that report for 13 years of my work there, just trying to improve Ohio's system. And the first thing we did was we created a juvenile appellate unit in our State Public Defender's Office, because that was one of the recommendations. So states really can take these reports and use them however it works best for them. And we're here to help. So how we analyze all the information, just so you understand what it is, how we come about our findings, how we come up with our recommendations. And you'll see this as you look through the report. So the report is kind of 2 large sections. The first one works its way chronologically through a juvenile court case, starting with arrest, through pre-trial, trial, post-disposition, and looks at, how do kids have lawyers? How do they get them? Are the lawyers ready for that stage of the proceeding? And then the second big section of the report kind of pulls back and looks at the system. But for both of those, we analyze it in the same way, and you'll see this pattern throughout the report. We start by explaining what are the federal constitutional rights that a child has at that stage of the proceeding or about that issue in the systemic part. What kind of federal case law is there? Are there national standards that explain what attorneys should do? Then we explain the state level stuff. Are there state laws, state standards, state case law that apply to this stage of the proceeding or the issue that we're talking about? And so we use that federal and state as our guideposts. And then we talk about what we saw when we were on the ground. And we say what we saw on the ground either met these federal and state regulations or their shortcomings. And we point those out as recommendations for improvement. So that's our framework. That's how we, we're not just writing in and, kind of making random decisions here and there. We really try to structure it based on law, case law, constitutional rights, and national and state standards. So the key findings in Utah, and these next couple slides, like I said, are kind of how I present this, no matter who we're talking to in Utah, and we'll dive in a little bit deeper then after this. So one, Utah has been through a ton of reforms in the last decade. And we were on the ground in all the counties. People kept saying to us, it has changed so much. I can't tell you how many people I talked to when I was in Utah who said, you know, I'd ask them a question in our interview protocol and they would answer it. And then they would say, oh, but if you had been here 5 years ago, I would have answered this completely differently. So Utah's been through a ton of reform, and it largely has been very, very positive reform, because you have increased diversion, decreased the number of children held in detention, decreased the number of children sent to commitment facilities, made it easier and more likely that children will get an attorney, not have to pay for the attorney. So there's been a lot of really great legislative and other reforms over the past, decade-ish. So that's great. Obviously, also the creation of the Indigent Defense Commission and the work that you all have done in less than a decade, which is really remarkable. So when the Sixth Amendment Center came in 8 or 10 years ago, I forget the exact timing, Utah was one of just a couple states that didn't give any state funding to indigent defense. And in the time since this commission has been formed, this agency has been formed, you've created standards, you're contracting now, as you all were just discussing, with managing defenders. You are starting appellate practice. So there's a lot of really good work happening right here with the IDC that is starting to lay a very strong foundation for a good youth defense system in Utah. So lots of great things happening and being implemented that I think give us a much different picture for this assessment than we would have had if we had been in the state even just a few years ago. That being said, Utah is still largely a county-based and contract-based youth defense delivery system. And what our assessment found as kind of the overarching theme is that county-based, contract-based system does have negative impacts on the quality of representation that youth defenders are able to provide to children facing delinquency charges. So taking just kind of a broad look at it, the big kind of overarching reasons why those contracting systems are limited is who gets the contracts are often influenced by county prosecutors and others who really shouldn't be involved in an independent defense commission system. Lots of the contracts don't provide adequate compensation for contract attorneys to be able to provide zealous defense. And largely the system doesn't allow for substantive oversight or mentoring of young attorneys. We also found that across the state, youth defenders are very much in need of specialized training. I'll get into this a little bit more, but between the time that we were on the ground and when we released the report, the state finished a federal grant that had been providing training for several years. People loved that. People across the state that we talked to absolutely loved all of the training provided through that program. But what we heard consistently is that lots of attorneys across the state, that was the first time they had ever received any youth defense specific training. And they were hungry for more. And frankly, they needed more as well. And I'm going to go into this last bullet point a lot here in a couple slides, but with few exceptions, youth defenders across the state lack the organizational infrastructure that they need to provide the quality of representation that they should be. I'm not going to go into that right here. We're going to get into that a lot deeper. That organizational infrastructure, I think, is really a very important theme of our entire report. So those are our key findings. You can read the whole report. We go into a lot of detail at each stage of the proceeding if you're interested. And our kind of overarching recommendations. So this is a big one, right? Really continue to work on establishing a strong statewide system for the delivery of youth defense services. And we get that that's a big, big ask. And something that county-based states like Utah, and there are a lot of states like that, aren't necessarily comfortable with. But interestingly, unprompted, lots of the folks that we interviewed for this assessment offered that up as something that they thought the system needed. Not really defenders so much, although they would often kind of go along with it. But judges, state level folks, even prosecutors and probation officers, we none of our interview questions are, hey, do you think there should be a statewide system, or should we move from contract attorneys to public defenders? We never ever asked that question. And lots of folks that we interviewed offered that as what they saw as possible solutions. So we get that, one, the state might not be willing or able to move to a statewide system. And even if you were, that doesn't happen overnight. But there are, we think, steps that the state could take toward that that would really help improve the system. One is the regionalization of defense services. And again, this is something that unprompted, we heard from folks that we interviewed, talking about how, there's the judicial system is in a district, has a district system to it, and that maybe providing defense services based on that judicial district model across counties versus county by county could really help with allowing defenders to specialize, providing some support services, etc. Providing truly substantive oversight of contract attorneys is another recommendation. And this is something we recognize that IDC has been working toward by contracting with managing defenders and trying to really start to dive into that. But making sure, and this is challenging, right? This is one of those things that in a contract system is more challenging than in a system where you have employees. There are a couple states that are good models. We highlight Massachusetts and Colorado in the report as states that do this pretty well, that Utah might want to look at, providing actual substantive oversight and management of contractors versus employees. Another way that we could start to move toward a statewide system would be to provide enhanced administrative supports, and I'll get into that in a little bit, and to invest in social workers. Another big recommendation is ensuring the independence of youth defenders. So I mentioned this as far as the contracts. There are lots of counties, at least when we were on the ground, where the county prosecutor, judges, other folks had a lot of influence on who got contracts to provide youth defense services. And there were reports of people, at least the belief that people sometimes lose defense contracts if they advocate too zealously and are a little too annoying to the prosecutor or the judge. And so we really need to ensure that defenders have the kind of independence they need to make sure that they're staying true to their client. That's who they're serving. They aren't serving the court or the judge or the prosecutor. Another recommendation is instituting pay structures that compensate youth defenders for the time and work necessary to provide competent representation. So the bulk of the contracts, at least that we saw across the state, were flat fee contracts. So an X dollar amount to take usually a certain percentage of cases, sometimes a number of cases. But those flat fee contracts, there's a financial incentive, frankly, for defenders to move through those very quickly. And because the contracts aren't sufficient generally for people to make a living, they are cobbling together multiple contracts, and many are also taking private paid clients. And because it's a flat fee contract, the faster they close out cases, the more time they have for their private clients. And the fact that the contracts themselves aren't enough to make a living on really introduces this kind of perverse incentive. We recommend to require initial and ongoing training. Like I said, defenders across the state hadn't had it and loved what they had received. Making sure that we establish systems for youth to access counsel at the earliest points of legal system contact. So at arrest for interrogation and at the diversion stage. We talk a little bit, we go into some detail about the diversion stage and how we have reports of kids saying no thank you to diversion because they didn't understand what their options were. So then they get petitioned into court, then you have a court hearing, you bring all these professionals in, it costs a lot of money. A defender finally talks to the kid and explains their options, and the kid says, oh, actually, I do want diversion. Getting defenders in there earlier can forestall all of that from happening. So that's kind of the overview that I give to everybody. no matter who I'm talking to about this assessment. I want to go into a little bit more detail with you all, since you understand the system a lot more and have the ability to hopefully implement some of these things if you're interested. So as I'm sure you probably noticed, that the title of the entire assessment report is A Tale of Two Systems. This is something that we really struggled with inside our organization about how to really try to kind of crystallize the theme of what we saw in Utah. So our site visits are entirely confidential. We never identify who we talk to. We also, with this exception that I'm about to explain to you, we don't even say what counties we visit, because we have learned that you know, if you say I went to these 8 counties, all the other 8 everybody but those 8 counties will say, oh, but that's not us. And we really want for this to be a statewide assessment. So generally, we don't even identify what counties we have visited. But as we are in that data analysis time period, we just kept circling back to the same theme. And we really couldn't figure out a way to tell the story of youth defense in Utah without explaining we essentially have one system in one Utah county, and then, you know, loosely there are exceptions, but then kind of the rest of the state is a different system. And it's about the organizational supports that youth defenders receive in that county. Not surprisingly, perhaps, it's Salt Lake County. The other reason we don't like to identify counties or specific jurisdictions is we understand that politically, a lot of times in a state like Utah, where you have one city that's, you know, by far and away the biggest and the most populous and has the most resources, that they're kind of sometimes is like an us versus them mentality. And so we don't like to call this out. But we just couldn't find a way to explain, like I said, the youth defense system in Utah without drawing these distinctions. So in Salt Lake County, youth defenders are full-time employees of an office. They receive a salary and benefits. An important point about salaries that's tied to training, and to think about as if you move down the path of trying to provide more training, is contract attorneys don't get paid when they're trained, right? They get paid when they're working on cases. And that's a perverse incentive for them not to go to training because they're losing billable hours. When attorneys are employees, like they are in Salt Lake County, they're on salary, they get paid to go to training essentially. So the defenders in Salt Lake are full-time employees. They have salary and benefits. They have their office space provided for them. Their technology is supported. They have administrative and other professional supports. The office has a management structure. They have performance reviews. They provide mentorship within the office. So it's not just outside training about adolescent development or anything like that. It's also the mentorship of new and younger lawyers being able to go to more experienced lawyers and talk through cases. They provide and support their attorneys attending initial and ongoing training. And they are able to specialize in youth defense because they're not piecing together contracts and private pay clients. So that's what it looks like in Salt Lake. And across the rest of the state, largely, and there are certainly exceptions, but largely speaking across the rest of the state, we're talking about contracted, largely solo practitioners. They have to rent their own office space, support their own technology, perform their own clerical duties. Like I mentioned, they're juggling multiple contracts and private clients just in order to make a living. They're having to navigate local political environments. I already hinted at this, where there are kind of power players who have more power than them within counties, making decisions about what contracts they can get or keep. And largely, attorneys across the state have little to no access to training and little to no ability to specialize. And so our theme, kind of, as we're looking at these two systems, is that organizational infrastructure matters, right? The attorneys in Salt Lake were highlighted from people across the state as providing the kind of representation that people wish could be provided across the rest of the state. And that's not just because they happen to be in Salt Lake or happen to, you know, live in one part of the state or happen to whatever. It's because they have all of these supports in place that let them actually be attorneys. They aren't small business owners. They aren't trying to flag down private pay clients. They aren't having to worry as much about the local politics. They have the time and freedom and space and training and mentorship and oversight to specialize in youth defense and really defend their clients in ways that's client driven. So what Utah youth defenders need, this is repetitive, but I wanted to kind of pair it with some quotes from the assessment. So training is a big one, right? Defense attorneys interviewed almost universally reported that they have received no youth defense specific training. So when we ask contractors across the state, when you got your first youth defense contract, what kind of training did you get? And they said, on the job. I figured it out as I went. So imagine that if your child were arrested and going to court and got appointed an attorney and it was their very first case ever in juvenile court and they had received no training, right? Is that the kind of attorney that you would want representing your child? That's a lot of the attorneys across the state. Another quote from an attorney, there are attorneys doing youth defense who know nothing about adolescent development. We literally talked to attorneys who were unfamiliar with the Supreme Court line of cases like Roper, Miller, Graham, JDB, very foundational US Supreme Court decisions about adolescent development that were somewhat unfamiliar to youth defenders, and so obviously not being argued in Utah juvenile courts. Defenders really need to be able to specialize. Especially in the less populated areas of the state, defenders are having to take any and all contracts they can. Delinquency, child welfare, adult, like I said, private pay clients, right? There maybe are also doing estate work and whatever else might be going on. But you really do need to specialize. This is tough stuff, right? You have to know all the criminal law and case law. You have to know all the juvenile law and case law. You have to know adolescent development. You have to know how to talk to kids. You have to be able to interview teenagers and explain to them what their charges are and talk to them about the theory of the case and the defense you want to mount. You have to talk to them about alternative programs, about their family situation, about their school. So they really do need to be able to specialize in delinquency defense in order to provide the kind of representation that kids need. Again, they need organizational supports. And this is interesting. So when we would interview defenders, often they would start from, I like what I have. I like my independence. I want to have my own law firm. I don't want anybody coming in here and making me be a full-time youth defender or a public defender. I just like it just fine the way it is. And then the more we interview them, and again, this is kind of a structured interview that goes along the same path as our report. We go through the stage of the proceedings. We go through different kinds of things like these organizational supports. The further we got into the interview, the more likely they were to say, yeah, you know what, actually, it would be really nice to have some administrative supports. It would be great if they would just provide me with some office space, or maybe if there was a centralized administrative support that we could tap into to help us with, organizing our schedules, to help us get experts and social workers. So there was that initial kind of independent streak that you do see in the defense community, but also, as we talked about it, a real recognition that they do need more of these organizational supports. They also need professional support. We heard a lot about difficulties getting investigators and experts. I think there has been actually some change in the expert funding, just even since we were on the ground. But when we were on the ground about a year ago, we heard in at least a few counties that the county prosecutor was controlling the defense's expert budget. I think that there's been some continued reform on that since then. But even if, and hopefully now, counties aren't housing their defense expert budget in the prosecutor's office, there's a need for training. Defenders don't know how to use experts because they've never bothered using them when the prosecutor controlled the budget. So now, hopefully, they have better and easier access to experts, but they probably need to be trained. Who's out there that's an expert? What kind of issues should I be getting an expert on? We also heard from them saying that if they wanted to hire an investigator, they had to front the money and that they might get reimbursed months later. So we really need to, and this is out of, contracts that are probably not even sufficient for them to make a living on. And then oversight and mentorship. And I want to make sure that we focus here on, the idea of supervision and the idea of managing attorneys isn't just a negative, right? It's not that we're managing or supervising them and trying to find the things that they're doing wrong. It's also trying to find ways to help them, to mentor them, to think through cases with them. And the last quote on here, it was someone, so the federal grant that provided the training also had, I think, a pretty small component that provided mentorship to some of the newer, younger attorneys. And we spoke to one of them who absolutely raved about it and said that mentorship experience completely changed my level of job satisfaction, because they watched me, they gave me advice, they just helped me think about my cases in a different way. And so when we think about managing defenders and supervision, we need to think about the mentorship aspect of that, especially for younger attorneys. And then how the defense system can help support strong youth defense, again, moving toward regionalization. And again, we heard a lot of support for this from folks all across different roles in the state. Supporting specialization for defenders and managers. So we talked already about specialization for defenders, youth defenders needing to specialize. There's also a lot of value in having managers specialize. So the skill set that you need to be a trial attorney is very different from the skill set that you need to be an effective manager. And so making sure that the managing defenders have access to training on management, have access to talk with each other about what it's like to manage defenders, especially in a contract system, which is challenging. Instituting pay structures that support zealous defense. Again, the flat fee contract system, and we see this in lots of states, incentivizes folks to move through cases quickly. Providing and requiring training. I've hit on that lots of times. I won't go over it again. And then ensuring of independence. And this is with the contracts. This is with the expert budgets. And then here's the quote about, we used to have an attorney who was a fighter and then he lost his contract. And again, whether that's actually what happened, who knows? There could have been, lots of other reasons why that person lost their contract. But the perception, at least among the other contractors in that area, is that guy fought hard for his clients and lost his livelihood. And so that really does have a chilling effect on the kind of representation that they feel like they can provide. So that's a lot. It's been a lot of me talking. There's the QR code to the report itself. I'm happy to send a link as well. Again, we are here to help you all however we can. So you decide what you want to do with this report, make it your own, and let us know how we can help. And I am happy to answer any questions that anybody might have.
Thanks so much, Amy. Okay, questions? It was a good presentation, so I'm not sure. And we also got it a while back. Matt had sent it out, and I think some of us have looked over that and read some of that, and so this wasn't the first time. It was helpful to have it presented by you, actually.
And this is not the only opportunity. So if you all think of other questions, Matt knows how to get in touch with me. We'll be happy.
Yeah, I love that you all continue to serve. Okay, I'm not seeing any questions, so.
I would just say it sounds like a very thorough report, and none of the suggestions seem to me to be unexpected. I think it's the same issues that we've talked about throughout statewide about defense services, and particularly because Utah's is so skewed in terms of population density that the smaller counties and all don't have the budgets and don't have the lawyers often. So regionalization is probably the only way to get career people serving geographically remote areas.
Yeah, that was our takeaway too, is that regionalization really could help address, we think, some of the issues in the less populated areas of the state.
Yeah, that was well stated, Commissioner Zimmerman. Yeah, not unexpected, and kind of mirrors actually the work that we've been trying to do in regular population. Yeah. Okay. Well, very good. If there are no other questions for now, then we'll keep going on our agenda. Amy, you can stay or leave. No doubt you're pretty busy. We have a few
Thank
more
you all so much.
that are- yeah, thank you very much.
Thank you, Amy.
Thank you.
Thanks, Amy.
Thank you.
Okay, so we have a few more. Oh,
Commissioner?
yeah.
Sorry, can I make a quick comment? You all may have caught this, but the training project that Amy referred to and that was relevant in this research was the one that we presented in past years to the full commission. Amanda Butler was a contractor who was handling it. And I think we and everybody who participated, Margaret was part of that group, Pam was too. It was very effective. We produced a lot of really good material. We did a lot of webinar trainings and full day CLE sessions that were tremendous. And then we are done. And so we have some good resources. We have some good materials available, but we don't have an ongoing mentoring program. We don't have centralized places where we can ensure that people are getting the training or having the training ongoing or applying it. So that's all obvious, I think, but it is a really good indicator of how we can do something really useful and productive and well planned. And then we've got to have a structure that supports it as we go forward, or we lose momentum.
Mm-hmm. Yeah, sustaining efforts to take you to a better level is huge, isn't it? Okay, good. I think that Matt definitely sees us and his office using this as a springboard for taking this great assessment from an outside entity and using this at the state for our legislators to be able to get understanding. So that'll be good too. Good timing in advance of the next session. Yeah.
Yeah, and I think one of the best advertisements is the way our taking over appellate functions, indigent appellate functions in the area of juvenile as well as in the adult for the smaller counties. And the results, the number of appeals, the number of successes that the juvenile appellate project has had is just reflective of what you could expect if we could do more with the juvenile system statewide.
Yeah, wow, it's a great thought. And for me, as a kind of a lay person who's been able to learn about all of this more, I think about, and I'm sure Commissioner Hopes thinks a lot about, just not only the importance of, robust prosecution and defense in our system, but just where you don't end up paying a lot of money for people to be incarcerated who don't need to be incarcerated. If there's a better way, and we don't have to be paying for more people to be, that's very expensive and often takes a great toll in moving ahead in a better way. So I think about that. Any data that we can help our legislature understand that, it's a big deal. Diversion, I really keyed into her saying that just even being able to understand better the option of diversion is huge. We talk a ton about diversion in our kind of in our UAC talks. How much more appropriate that can be sometimes to find the balance of what we're paying and helping people be able to move forward in positive ways. Just options, there should be options. Okay, well, great. Thank you so much, all of you, for being able to be here and hear that. Okay, so the next thing here is Matt talking about the 5th and 6th District Juvenile Court Project.
So, thank you, Chair Kamalu, and you're right. Having received this report a couple months ago here at the IDC staff office, we've been brainstorming and thinking and planning about how we can implement some of those recommendations and improve youth defense statewide. And so what we have for you is a project that we have put together where we think it's a great first step. So rather than taking a look at the entire state, which seemed frankly to be a little bit overwhelming, we thought, where could we make the most impact, and where is the need the greatest as well? And so what we landed on was the 5th and 6th district. A couple of reasons for that. One is that there is some larger population centers there in St. George and in Cedar City, where you actually have some local attorneys who are there to be able to do the work, because I know it's important to have that local presence and accessibility for the clients that they're representing. One thing too, as I get started, is that we thought it would, a lot of the findings and themes in the report apply to child welfare cases almost identically, right? There's the specialization, there's the need for specialized training, there's the need for management that has that same background in training. And so when we're putting this project together, we included child welfare cases in that analysis. And so the project that we have would take a look at both juvenile youth defense and also parent defense as well. So the goals of the project mirror those from the report: achieving specialization, improving the quality of representation, increasing the management and oversight, and strengthening the independence of the people doing the work there. And I should thank Leslie in absentia for putting these slides together. She spent a lot of time looking at caseloads, and one of the challenges of a project like this is not only you can't just look at the caseloads and say, all right, this is how many attorneys we need. Because of the unique nature of juvenile court, you really need to have take into consideration the different calendars that the judges have, because sometimes in the rural cases the calendars are kind of not as frequent and not as often, and so it's very much putting together a puzzle to make sure that everything works. And so thanks to Leslie for doing that. Currently, what the status is in the 5th and 6th district. So here's a breakdown. This is a 2-page look at it. We have 4 attorneys in Washington County spending about 30 to 40 hours a week in juvenile court. They have a mixed caseload, so they do both parental defense and youth defense, and they appear in front of they appear in court 4 days a week. So they spend a lot of time in court, and that makes it hard to do any kind of outside work, not private work necessarily, but if they need to do research or writing and look at memos, their time is pretty limited because they end up spending so much time in court. Iron County, there are 2 attorneys doing the work there, again, having a combined caseload. In Beaver County, there are 2 attorneys. One is primarily doing parental defense and a little juvenile delinquency, and then the other one has a mostly adult calendar and handles some conflicts from juvenile court. And then in Kane County, that's a smaller system there. We have 1 attorney who handles everything. So we've made an effort over the past few years to really separate out the juvenile contracts and child welfare contracts within a system, but that is not it's not extended to a regional project. So that what we've ended up with is having specialization within a system in some cases, However, with some of these more rural ones, the caseloads are just too small that it doesn't make sense to do that within the system. Continuing on into the 6th district in South Peak County, there are 4 attorneys. Here we have some of them doing both again, but more of a specialized situation there where we have a youth defender and then some doing parental work, but then handling conflicts for juvenile cases. So here we have 5 attorneys where they've they've been able to separate the contracts and have those be specialized with either youth or parental defense. And then Wayne, again, a smaller system where there is a primary juvenile court provider, but that's a mixed calendar with youth defense and child welfare defense. But overall, if you add those 2 districts up, what you see is that we have 17 different attorneys handling these contracts, and there are 23 contracts spread out amongst those counties. So we have a lot of people handling a lot of different contracts. But when you consolidate those and you regionalize those between the 2 districts, and if you were to have these be full-time contracts, you would just need 8 attorneys to do that work. So that would be essentially 4 attorneys doing child welfare cases and 4 attorneys doing juvenile delinquency cases. So there's a lot of inefficiencies with the current system where you have those contracts spread out so thinly. Here are the current caseloads, if we want to dive into those numbers, but for each system, there is a little caveat there where the data that we receive from the courts on child welfare cases are a little bit hard to get a handle on because the way that they report that is per child rather than per parent. You know, we look at it as how many attorneys is it going to take to represent each parent, but the courts look at it as per child, and there may be a situation where you have 4 children and 1 parent, so 1 attorney can handle that case. So Leslie has done her best to come up with a good estimate as to what the caseloads would be like in those situations by taking the court data and then also what the attorneys are reporting their caseloads to be and finding something and kind of averaging those out. Here are the caseloads again for Sanpete and Paiute, Wayne and Sevier. You can see with those smaller caseloads or the smaller systems, we only have just a couple cases a year. So nevertheless, we have attorneys handling contracts for those small caseloads where instead of having an attorney in that county having a specific contract for that county, it would make much more sense to regionalize where they could travel between counties and handle those cases that way. So, as I mentioned before about having the difficulty in looking at calendars and figuring out how we could actually make it work in practice, Leslie's taken a look at this. This is for parental defense. Now, the target caseload for parental defense cases is 50 cases a year. And so you can see on the right-hand column here, that is the total cases that each of these potential attorneys would be handling. So some of them are close to that 50 number. Some of them are a bit shy of that 50 number. And so those attorneys we would need to fill those up with other responsibilities. It could be administrative responsibilities. They could be designated as kind of a research go-to to look at, to file and draft motions and the like. But this is the best way that we could look at the different court calendars and ensure that attorneys were available to cover each court calendar with parental defense cases. And we built in also knowing that there will need to be conflict contracts to handle some of those where you have parents who are involved in the same case and have adverse interests there.
Matt,
Yes,
I just ask a couple of questions.
please. Yes.
One, if, you know, this model at some point were to be adopted, would you consider like that all 8 attorneys would be part of a single entity?
So that's a good question. And I think that, again, going back to like the management piece of it, you know, what's important is that they be managed by people who are specialized in that particular field. So whether they're part of the same entity or not, I think what's important is that the people who are doing the management and supervision are specific to that practice.
The main reason why I asked the question is because of the nature of child welfare cases and sometimes delinquency when you are treating both, you know, have parental representation and then sometimes youth representation in that same family. And sometimes, you know, you may have a case with 3, 4, 5 parents that each need their own attorney. And so that's when it becomes, you know, challenging to juggle, and why oftentimes at least so many bodies can be required.
Yeah, sure.
So I was just curious. I mean, that's getting way ahead of where things are, but
it is, but it is something important to think about. And, you know, I think we are trying to be flexible about that as well, right? There's a few different ways we could go about it. One is by, you know, on one end of the spectrum, they could all be state employees, but then on the other side of the spectrum, they could be, again, either contract employees, but with their caseloads or the contracts being regionalized to the point where it's an essentially a full-time contract. So they're not running around cobbling together separate contracts and taking district court cases as well, or private cases, but they've got enough work to do in that area of specialization. And then because we've lumped those contracts together, they are making enough of an income that they don't have to go out and chase private clients as well. And again, with these two areas of specialization, you know, they don't necessarily need to be the same model as well. It could be that one is contracted and the other is employee, or they're both the same. So I think there's a lot of thinking to be done to see how that's going to work best. But as far as regionalizing the system that's in place now, I think that will make a huge improvement from the way things are right now. As far as the delinquency contract for that, for those districts, again, we were able to look at the court calendars and try to have it so that there's one designated attorney for each calendar within each system there. There is this red highlighted there. That's one where where we don't have an easy answer for those 22 cases on that particular calendar because it conflicts with all of the other judges' calendars. And so there may be a need to have maybe a part-time person there, again, a part-time person who could have other responsibilities. As far as the money goes, right? So we are acutely aware of resources and what we need to make this happen. The current money that's existing within the system, both with state and local dollars, it's a little bit hard to entangle in some cases because some of the contracts that are out there are mixed, especially when you're looking at some of the managing defender contracts, because they have juvenile court caseloads, but then also they're responsible for doing some administration for the entire county. And so there is some district court overlap there. But the grand total of potential funding or existing funding within that district as it relates to juvenile court is approximately $1.25 million, with about half of that being from grant funding. If we were to look at just the attorney costs and we took we erred on the side of needing too much, right? Or on the high level there. So if we had 8 attorneys with benefits and being paid $150,000 plus benefits, plus the additional contract costs to handle those conflicts, that would put the total at 2.250. So even if we are looking at the high side of things, because an attorney who's newer is not going to have that high of a salary, we are looking at a additional $1 million that it would take to implement this project on the attorneys. Of course, in addition to the attorneys, we would need some other overhead costs, such as the administrative assistants, some physical spaces for the attorneys to meet with their clients or to meet together, equipment and the like. So that would be some additional costs outside of that additional $1 million. So that is where we're at with our project. But before we started really bearing down on it and figuring out some of those other questions that were raised, as far as what kind of structure, would it be employee or contracted out, we wanted to get some feedback from you here at the commission to see if you had any thoughts or concerns or encouragement as we try and implement some of those recommendations from the GALT report. One other slide, again, we're talking about the management structure. We, of course, would be foolish not to include Pam in a lot of this conversation and planning, simply because of the level of representation and the experience that she and her firm provide here in Salt Lake. And we did discuss the possibility of, all right, if we were to separate this out and have the youth defense attorneys, could Pam's office potentially handle the management and support and structure for those? And so that is one possibility for the management of the youth side of things. With the child welfare side, there's I think we would need to source some managers and administration on a more local level. Talked about overhead. And then questions and comments or concerns from the commission. I really appreciate any feedback or comments on this.
Yeah, thanks, Matt. I just have one question. And it's not really focused all the way just on what feedback you're wanting here, but the regionalization that IDC has done so far, does it align with the district court areas?
In part, so with some of the regionalization, we have tried to keep it within within districts, because you're working with the same judges, and that makes it easier with the court calendars. With these two particular areas, there is some regionalization in place. There are some counties in the 6th district who do not participate with the grant program. Those are some of those small counties, Panguitch and Garfield.
Paiute, yeah.
Paiute, yep. And the regionalization that exists right now is mostly on the management level, right? So that's where the regionalization is taking place, is with the management, data collection, and the like. But the contracts themselves are still on a system or county level.
Yeah. Yeah, I'm curious to know who anyone have immediate comments or questions. It seems like a good effort to move this direction. That's about all I have right now.
Yes,
I agree. I agree with.
Yeah.
Sorry.
too.
Oh, that was Senator Weiler. You said you agree?
Yeah.
Mhm.
I didn't mean to talk over anybody though. Sorry.
Margaret.
So this is Mike Drexel. Can I ask, this is Mike Drexel in Matt's office. Is the problem that would be fixed worth $1 million ongoing? I guess what I'm wondering is, are the deficiencies that are going on currently and the representation that both parents and juveniles are receiving in these areas by the 17 attorneys with 23 contracts so deficient that it's $1 million plus problem to solve? Or are we just regionalizing because we're told that that's the better model? Because my thinking is, if you have 5 attorneys or 8 attorneys that are working in such geographically disparate areas, what is the level of oversight? What is the level of collaboration? What is the level of involvement with each other that would flow through, which is one of the primary benefits of regionalization, right?
Yeah, no, that's a great way of thinking about it, right? And I think that's a challenge to quantify some of those outcomes. I mean, we could look at outcomes as far as the client's experience, pre and post regionalization. I think that it's clear, though, that compensation is an ongoing issue with attorneys, these contract attorneys throughout the state, where they're, so say in Washington County, for example, the attorneys who have contracts who are handling child welfare cases are literally making half as much as the AGs and the guardian ad litems who are in the room with them. So I think some of a lot of the costs would be with that compensation piece of it too. That would be something that would have a dual benefit, because you're helping attract and pay people what they're worth. But then also you have the added benefit of having that specialization where they're ending up being better trained, better equipped to represent their clients. And some of that additional funds would go towards the management, having that specialized management to ensure that those people who are doing the work are doing it well, and they're getting the training and support that they need to be able to do their jobs the way they should be doing them.
Can I add something to that, please?
Yeah, go ahead, Adam, and then we'll go to Margaret. She's
Okay,
also
great. Sorry, Margaret. Let me just say, I really like that you asked that question, Michael, because it's a question we have to answer, right? And from our perspective, I think we're not just being told, yes, there's a better way of doing it, but we really are looking at the whole structure that we all have been working on for a while and saying, does this disparate contracting structure separated out between counties with a lot of independent contractors, is that a good way to handle defense representation? And I mean, my answer easily is no, but what is our argument in favor of going the direction of the other parts of the system? I think that's something we do have to be able to demonstrate. So I have my strong opinion, but if we're going to explain why it's worth the 2 million, we do need to be prepared with a good explanation about why the other systems are actually working better.
Yeah,
So,
thanks. Margaret?
I just, first and foremost, I wanted to, thank Matt and Leslie for their work and, bringing us a presentation on, a possible next step that could be not only applied fifth, sixth district, but then we have to look at the other districts. And I think we're still are the question of not only the economics question that, Michael raised and how that applies statewide, not just fifth and sixth district, but, are we in a situation when we're one size fits all, and is that the best solution around the state? So while I have a lot of questions, and I'm also grateful for the work that's been put in and the opportunity to see what a new regional system could look like. And I've got to run.
Can I just say, I was just gonna say, I mean, I guess, Michael, I don't know the answer to that question you're asking. I mean, I don't know. Matt and Adam talked to the defenders, I think, as part of this in other parts of the state. So I guess I'd be interested to know, not with a solution, I don't think, because no one knows what the solution is yet, right? But like with at least an idea of like, how do you feel, like, what are the challenges and things like that. But I guess one of the things that I would say is when we're working with like the statewide appellate office, there's no appeals and no motions practice going on outside in those other areas. And so when you say, what is the deficiency of or what does $1 million fix? When you're talking to people and you're saying, even with the supports that
I don't know if that's on me or her. Sorry, Pam, we just lost your audio on our end. I don't know if that's just us.
We're hearing, it might just be you. Can you hear me,
It
Matt?
might be me. It might be.
We can hear.
I can hear.
Okay, we couldn't hear in here. I think our bandwidth was fluctuating a little bit. We had some internet issues in the office today.
Sorry, Pam, go ahead.
Well, I mean, and I'm not saying that I know the answer to that. I'm not posing that but I'm just saying that's something that like we've been working with like Matt's office through the appellate division on for like the past several years, is how do we encourage and support motions practice, trial practice, and stuff like that? Because, a lot of like what Deborah Nelson is talking about with the appellate office is, how is it possible that you have those many cases and like you've never had a motion to suppress in so many years? You know what I mean? Now, to Michael's question, is absent the motion, the resolution still just as good as the cases where the motion is happening? I don't know the answer to things like that, right? But my question, and I think that's what we've been working with IAD about, is that stuff happening? And if it's not happening, why is it not happening? And I think, there's some real work that we're doing with IAD to try and help move some of those things along. But I guess those are questions to me, is that I think it's hard to understand how in certain situations these types of, and like I said, different areas of the state are different, right? I mean, it just is, we all know that. Like, to Margaret's point, like some areas of the state, they're resolving things in certain ways, and in other areas we are arguing about different types of issues and stuff like that. But I do think that type of stuff and like the feedback from the defenders is helpful in understanding some of it. Now, whether or not it's fixed by any of this stuff, and like I said, Michael, I don't know if it's maybe the outcomes in the court system are still the same, but I feel my question is like, are we getting to some of those like crucial legal issues?
Yeah, great question. I think just just a little tiny bit for me is that, probably Casey and I, because all of you are experts in this area in one way or another. Like Michael's question is certainly big because we're gonna have to be able to argue to a lot of people like me and Casey. You know, the return on investment, I guess, or how we're deficient in the amount and the why it's so important for us to spend more money. There's got to be real concrete things that people like us can understand, me and Casey. I would like to think that just lots and lots of legislators have that trust and confidence in the people who are the experts, but everybody knows that, you know, there's the money is always, requests are always bigger than the amount of money, and so you kind of have to become a priority for some reason or another. Anyone else? We're not giving you a ton, Matt. I don't know. What other questions do you want to ask more specifically?
I mean, I guess, I don't know how we would get, the information Michael's asking for other than analogizing what's happened in other areas where we have begun to build some expertise and where we've restructured things so that people are careerists at what they're doing. And you can go back to the late 2000s when the Supreme Court asked us to look at appeals in the rural areas, and we found there weren't many and what there were taken were abandoned before they were ever heard because of financial reasons and lack of expertise. And we've changed that, and it's made a huge difference. And I think, like putting managing defenders in place maybe hasn't had that big a difference, but certainly the juvenile appeals project has, I mean, the statistics are maybe skewed because we've had some really big positive results, but bringing expertise into a relatively disorganized part-time system in other places has played well. Now, is it worth $1 million? You know, $1 million is a lot because we don't have a big budget, but certainly seems to me our past experience suggests that we ought to look really hard at getting this done, and how can we structure it in a way that's politically feasible for local governments and for the state administratively.
Thank you.
But I think to reflect back on some of the prior meetings that we had, I mean, I think it was a few months ago that we had a meeting and we're talking about strategies and themes and what's going to resonate with decision makers, both local and at the state. And one of the things that you brought up, Commissioner Zimmerman, was that idea of equity, right? It's how much money is being spent by the state or by local systems on prosecuting these cases, right? And comparing that with the amount that is being spent on defense. And I would be willing to bet a modest amount of money that this $2 million, overall on child welfare and juvenile defense would be just a fraction of the amount that's being spent on AGs and guardian ad litems and prosecutors who are prosecuting the youth cases in those districts.
Yeah, good point. Adam,
Just says quickly, I think we're talking about far more than $1 million, but we're talking about more than $1 million. And I think these are all great comments. One of the reasons I like the question is because we do want to be able to say, where are the deficiencies we really can show? And the simple answer is, well, apparently the other structure of centralized structure, training, management, and dedicated employees must be working somewhere because the others that we're opposing in this system on the juvenile side are using it. So it doesn't have to be a matter of deficiencies, but it is that question, where do we have gaps that we see that we want to argue for? And I say it's more than $1 million because in our office, we haven't really decided exactly what it would look like. We haven't decided what we would recommend the counties contribute or not contribute. We don't have a definite answer on what the structures should be. There's a lot of questions, but the fundamental thing we're doing with the IDC, obviously, is trying to figure out where we make improvements and what they look like. And so we know we have deficiencies. How do we argue for a specific structure? That's what we need to come up with, but we also need to decide what the best structure is for that. So there's a lot of pieces still to talk about, and I think that was Matt's point. Do we have support? Do we have support from the group remaining to go forward and really push more of this discussion and see where we take it?
Yeah, we've had a lot of people have to leave. Some of them have put that in the chat. And Senator Wiley, you came off mute just a few minutes ago. Did you have something that you were going to say?
Well, yeah, I was just this is my speech I always give, and I don't think anyone's advocating for the same amount of money for prosecutors as for indigent defense, but I just like to always remind legislators, at least, prosecutors have to review cases that aren't charged. Prosecutors bear the burden of proof. So I would never advocate for equal money, but I do think that at some point a percentage, is helpful in looking at what are we spending on prosecution versus defense.
Thank you. Yeah, you're right. I remember Rich Morrow saying once that in his jurisdiction, they talk just about market forces, and they talk about, staying competitive for defense jobs. And I think that is absolutely an overarching area of interest and concern for this group.
And let me clarify, I'm not talking about salaries. I think salaries should be commensurate. I'm talking about the overall budget.
Yeah, right. Thank you. Yeah, so with everyone who's left, I don't see anyone really opposed, just questions of, what we need to figure out as we go forward.
Well, we certainly appreciate all the support that we receive, both on this project and in general, but we appreciate everybody being here and your attention to this this important issue, and we look forward to more support and collaboration as we develop the project.
Yeah, it's big. You're being visionary. Good for you and your team. Thank you. Okay, well, since we're dwindling with time and numbers, Matt did have a quick update for us with commissioner terms, because we do have some folks who are wanting to be reappointed, and some folks who, for whatever reason, cannot be. So he's going to give us that little update. I think that's it, right, Matt?
I believe that's it. And so, since so many people started at the same time, way back when at the beginning, a lot of those terms are expiring at the same time. So we have a bunch of terms that are expiring. And so I'm happy to report that Commissioner Zimmerman and Commissioner Drexel have both agreed to renew for another term on the commission. We certainly value and appreciate the thoughtful advice and counsel that they've given over the years, and I'm glad to see that continue. Mary Corporon, Commissioner Corporon's term is ending because of the transfer of the aggravated murder defense fund to the IDC, and she's one of the contract holders and providers under that. She felt it would be appropriate for her to not renew, and because there could be a conflict of interest there. So when she's back around, we'll definitely celebrate her and thank her for her term. We're working with UACDL for someone to take her place on the commission. Commissioner Luce, likewise, his term is up. He checked in with the league to see if they wanted him to renew, and they indicated that there were others who wanted an opportunity to be on this highly sought after commission. And so unfortunately, he's not going to be renewing. So again, we'll express our appreciation to him when we're able to. And then with Commissioner Hopes, I did reach out to UX since he's not running for re-election as a county commissioner there in Carbon, and they have put forward the name of Commissioner Kendall Thomas from the council person, rather, from Tooele County. So I'll be reaching out to him to get his name to the governor and have him introduced to the IDC and what we do.
That's great. Yeah, we're so thankful, Casey, that you came in and really hit the ground running with this group. It's such a great job. Okay, yeah, that's a good update. Thank you for that. And then no public comment. I don't think we have any members of the public here in the meeting. And then, are the terms 3 years, Matt? I was trying to remember. It seems like
4-year terms.
Or 4-year term. Okay, just like what we do as county commissioners. Okay. And then other business, we were going to come back around to Pam. I don't know if anyone's had additional thoughts about Pam and that was say it again, Pam, the right terms.
Oh, just the police reports. But I think I got the feedback based on everybody's facial expression when I said it. So I just was trying to figure out if it was a theme running rampant throughout the state. So I think I'm good. Thanks, Lorraine.
Yeah, I feel like the little I noticed or knew about your question is just that it pops up for a while and then goes back down, which so many things in government do that. That's what I know. Okay. All right, good. I'm glad you asked that question. We have time in the beginning. All right. Well, with that, I think we've been through everything, right, Matt, for today?
Oh, we filled the time.
Yeah, we did. Today was longer, but good. Certainly, we had a lot.
Yep.
All right. Well, then it is 3:55, and we will adjourn for today. And our next meeting, sometimes that's on this agenda, but not today. Who can find that date the fastest? It's usually the 3rd Thursday, right?
Yeah.
So that would be August the 15th, and I do see one on the calendar for that day. So yeah, Matt will keep us updated on that. And I know you were going to talk a little more at some point about the capital discussion with Utah County, right? And their interest in joining.
Yeah, I have not heard back from them. I reached out with some of the questions that were raised when they brought that up and asked for some historical data from them, and did not hear a peep. So I think they might have moved on to other options to handle some of their cases. So
Okay, that's interesting. Good to know.
Mm-hmm.
Okay, yeah, hearing nothing tends to hope you know not to spend any more time on it until you hear.
I did meet with the county manager, Utah County manager, after I had sent that email and had those questions. So he didn't raise it at that time either. So I think they've moved on from that request.
Okay, yeah, good to know. All right, well, now it's 3:57. We're still in our 2-hour window. Thank you so much, everyone. We'll go ahead and adjourn and have a great weekend coming up.
Yeah, everybody, happy Pioneer Day.
Yeah, happy Pioneer
next week.
Yeah.
Thank you, everyone.
Thank you.